Hey there, everybody. This is Jesse Weber, and welcome to Law and Crime Now. We're going to start with the latest in the Chad Daybell, Lori Vallow saga. As you know, the bodies of these missing Idaho children, Joshua J.J. Vallow and Tylee Ryan, were discovered on the property of Chad Daybell. Now, in a recently released probable cause affidavit, we learned that authorities were led to this burial site by the cell phone data of Lori's brother, Alex Cox. So his involvement in all of this is now under extreme question. We've also learned that there's a name, Melanie Gibb, somebody you probably have followed in the course of this whole case. She was the former good friend or best friend of Lori Vallow and Chad Daybell. Well, she was discussed a lot in this affidavit as probably one of the last people to see Joshua alive. She sat down for an interview with NBC's Dateline, and if you haven't seen it, here's a snippet.
They were both like gasoline and fire. Not a good match.
Here is the confidant who saw the combustible beginnings, who once shared their warped religious beliefs and learned enough secrets to make her afraid.
You're in hiding for a long time.
I didn't want the media to see me because, my friends that I thought were my friends are now being called murderers.
Okay, a lot to get to. Let's bring in my panel for tonight. We have with us our very own Law and Crimes, Julie Rendelman and Terri Austin, as well as New York One reporter and anchor and attorney, Lydia Hugh. It's great to have everybody here. Lydia, I want to start with you. Welcome to Law and Crime Now. I want to talk about Melanie Gibb because she has been criticized for her recent statements. They basically say, she came out too late. She knew what was going on. She should have stepped forward. What role do you think she has played, or maybe will play, if we're talking about upcoming trials, in this case?
Well, thank you so much for having me, Jesse, and everyone. I think, the account that we're hearing from Melanie Gibb that's coming out right now is fascinating. And I think it's probably just the tip of the iceberg. What we're learning from her is that she was approached by Lori Vallow to basically kind of cover up where her children were. Lori Vallow, we hear, asked her to tell investigators that JJ, her son, was with Melanie Gibb at her home. I believe that was in Arizona. And she said that when she learned that that's what Lori Vallow wanted her to do, she was shocked, she was stunned. I think it's not good that she took a while to come forward, but I'm not especially clear how long she's been speaking with investigators. We're just now learning here more about her account in the public forum, in the media. I think we can look forward to hearing more from her, seeing her participation in trial as she continues to evidently work with investigators.
You led me right into it. So, Julie, participation in a trial. We cover trials all the time here on the Law and Crime Network. Let's say we fast forward and there is a trial for Lori Vallow or Chad Daybell. Who knows what charges they would face at that point, because we're going to get into that in a second. They are currently facing different charges. Do you think Melanie Gibb would be the state's key witness here? And do you think that she would kind of open herself up to extreme questioning by a defense attorney?
Well, I think Lydia makes a good point. I think there's a difference between what an individual witness says to the public and what law enforcement knows. And we don't necessarily know what law enforcement may know that we didn't know along the way. And quite frankly, we shouldn't know everything, because that's part of their job, is to keep it tight-lipped until they know more themselves. At the end of the day, I think she's going to be a key witness, certainly as regards to Lori Vallow, because she establishes one piece of evidence that shows that there would be no reason for Lori Vallow to lie about where her child was unless she knew her child was dead, which again goes into the idea of her being involved in some way with JJ's death.
So I want to bring our attention to something. This is a very complicated story, and a lot of different people are involved. Charles Vallow. Now, Charles Vallow was the former husband of Lori Vallow. He has since been killed, or he's been killed by Alex Cox, who, again, his involvement, we're going to talk about it in a minute, but he was the former husband of Lori Vallow, and he kept contacting police before his death and said, I'm worried about Lori. I think she's lost her mind. She's lost touch with reality. She's threatening to kill me. Her religious beliefs are bizarre. Let's go back to January 2019 when he calls 911 expresses these concerns. Now, you're going to hear a lot of terms about community bridges. That's a mental health facility that Lori eventually checks herself into, and she's cleared by them. So you're going to hear that in this call, but there are some eerie things that you're going to hear from Charles Vallow. Take a listen.
Gilbert Police Department, this is Dee.
See, my name is Charles Vallow. I've got an order to hold my wife. You can look it up, Lori Vallow.
Uh-huh.
And go ahead.
Yep. We spoke to you earlier about her.
Right. She is at the Gilbert PD saying I stole her purse. I'm going to go over there, and the officer said he won't hold her because he doesn't have an active order. Can you get that to him like immediately? I'm going there right now.
Okay, just one moment, sir.
Thank you.
Is she in the lobby right now?
That's correct. Blonde hair.
Okay. And how far away are you?
I'm about 10 minutes away.
Do you want officers with her?
You're at Civic Center Drive? You're on Civic Center Drive?
Yes. 75 East Civic Center Drive. And do you want officers to go down there with her?
She's supposed to be retained for bridges. I got an order last night. She's lost her marbles.
Okay, we'll get in contact with our front office or our lobby.
Okay, but I don't want to go there if she's going to not be.
Yeah, I'm going to call them right now.
Can you call me back and let me know?
I can have an officer contact you.
Terri, what's so eerie about that is we know that it would be only a few months later that Charles Vallow would die. And obviously there's a series of deaths that are connected to Chad Daybell and Lori Vallow that are under questioning. What do you make of that call there? Because as we try to analyze and understand what's happening, what should we think about this and how will this affect her upcoming trial?
The first thing I would say about that call is you can sense the fear in his voice. He's being, very calculated, but you can tell that he's afraid of Lori. He doesn't want to go to the police where she is. He wants to give this information, but he doesn't want to reveal himself. And you're right, there has been a series of deaths, 2 ex-husbands. We know Terri Daybell, the ex-wife, and we know Alex, the brother, and obviously the 2 children. So every single person around Lori Vallow has died. And I think what I hear in that call is the fact he was afraid, and sure enough, he ended up being killed.
Julie, you got to explain something to me. You watch this, you read this probable cause affidavit. It seems Alex Cox played a direct role in what happened here. I mean, it's alleged that he was actually carrying JJ the night before he disappeared. And when Melanie Gibb said, where's JJ? Lori had said, oh, Alex took him away. So is there a possibility here that, as we question, how come there are no new charges against Chad Daybell or Lori Vallow? Murder charges. There are 2 kids. Their bodies are found on his property. Is there a possibility that either authorities can't connect this to anyone, their deaths, or this is only right now the evidence linked up to Alex Cox and maybe no one else? And let's not forget, Alex Cox is dead. He himself is dead. So what are we thinking about here if that's a possibility that he's really the one and maybe the only one authorities can tie the deaths of these children to?
So it's a great question. I wish I had the answers. And I think one of the things that, you hear a lot of talk about individuals, whether it be in social media saying, why haven't they made arrests? Why aren't they doing their job, in terms of prosecutors? As a prosecutor, there were times when we waited to make arrests because we wanted to make sure, A, we had the right guy, and we had the evidence that would make sure that we could convict that individual beyond a reasonable doubt. And so we have pieces of evidence against each of these individuals. We have evidence against Alex regarding some of the GPS and obviously some of the other things that we've talked about. We also do have evidence regarding Lori, because even if we talk about what she said to Melanie Gibb, that is evidence that could establish that she was a participant and was covering up for the crime she committed. So, I don't know what's going to be. At the end of the day, do I think we're going to see indictments for Lori Vallow and or her husband, Chad? I do. But, again, maybe there's more evidence out there that we don't know about.
Yeah. And look, people are reacting to this developments in all different ways. We know that Lori Vallow's sister, who actually went on TV and defended her family, she now said, I was wrong. So the big theme out of all of this is that the Daybells deceived a lot of people. What's going to happen next? What details will come out? We'll wait and see. We'll follow and we'll report on it. When we come back, we're going to focus on the Rayshard Brooks case and Ahmaud Arbery. Stay tuned. Welcome back, everybody. It's time to focus on Rayshard Brooks, the Atlanta man who was killed by police after a struggle with arresting officers. Those arresting officers, Garrett Rolfe and Devin Brosnan, have each been charged. And it's at this point we are hearing reactions. So Devin Brosnan sat down with a local media outlet and said he's waiting for the truth to come out and he did nothing wrong. DA Paul Howard, who brought those charges, he's facing criticism for bringing charges before the GBI, the Georgia Bureau of Investigation, actually finished their investigation. He's defended himself and said that the evidence supports the facts. He didn't have to wait for anybody. Actually, let's listen to DA Paul Howard during the first announcement of these charges. Take a look.
Once Mr. Brooks was shot, there is an Atlanta policy that requires that the officers have to provide timely medical attention to Mr. Brooks or to anyone who is injured. But after Mr. Brooks was shot, for some period of 2 minutes and 12 seconds, there was no medical attention applied to Mr. Brooks. But when we examined the videotape and in our discussions with witnesses, what we discovered is during the 2 minutes and 12 seconds that Officer Rolfe actually kicked Mr. Brooks while he laid on the ground, while he was there fighting for his life. Secondly, from the videotape, we were able to see that the other officer, Officer Brosnan, actually stood on Mr. Brooks's shoulders while he was there struggling for his life. We were able to conclude that based on the way that these officers conducted themselves while Mr. Brooks was lying there, that the demeanor of the officers immediately after the shooting did not reflect any fear or danger of Mr. Brooks, but their actions really reflected other kinds of emotions.
All right, so Lydia, I want to start with you. Should the DA have to defend himself? I mean, he presented a very articulate, well-reasoned legal argument here, yet he didn't wait for the GBI to conduct or finish their investigation. Does he have to defend himself, and what do you think of his defense at this point?
I don't think he has to defend himself at all. He's the district attorney, and he is fully within his ability, his authority to bring the charges. He doesn't have to wait for the Georgia Bureau of Investigations to conclude their investigation. His office is fully capable of reviewing the evidence, as he says, and they can bring the charges when they're ready, when they feel they have the evidence to support those charges. It's that office that will be pursuing them and pursuing the conviction based on beyond a reasonable doubt. So it's up to him to decide when those charges will be filed.
Terri, what happens if the GBI comes out and they disagree with the findings and theories of the DA? I mean, are these charges set in stone? What will happen if that's the case?
Well, charges are never really set in stone. You can see charges change. They can be elevated or they can be lowered. I think these are about as high as they get. I think there's the old adage as far as DA Howard is concerned, you can't win for losing. You can't please everyone. And I think what he tried to do here for Rolfe and Brosnan is to make sure that he put the highest charges possible. So based on the evidence, that can be dropped down if necessary. And I don't think the Georgia Bureau of Investigation is going to come back with anything stronger. They may, in fact, come back with something less, in which case they can proceed with the prosecution, with the DA, and they can determine afterwards what exactly the jury might find out in terms of the evidence.
Yeah, it'll be interesting to see what they actually say. I want to move on to Devin Brosnan, though. Julie, he does this interview, defends himself, said he didn't do anything wrong, said he never intentionally tried to hurt Brooks. He rendered first aid as quickly as possible, despite what the DA says, because he's charged with a violation of his oath for not rendering aid quickly enough. He says that he had a concussion. That really affected things as well, and he didn't really know what was going on. And he says he really did nothing wrong. Now, it's interesting to see defendants coming out and speaking to media outlets about this. In any case, your thoughts on his response?
Look, I don't like when any defendant, witness, even prosecutor comes out and makes statements that start to talk about the facts of the case. As an attorney, I would never, ever, and everyone knows this, ever allow my client to ever make a statement in a national format, especially when his words can eventually be used against him. With that said, he does, if they're true, make certain points that, if true, are going to help him. One is, if in fact he did suffer injuries when he was pushed down and did have a concussion, that may impact his ability, or the argument would be his ability to run and get aid, because he is, in a sense, not fully aware of what's going on. He can also argue that the other individual Rolf went to get some of the assistance. So, who knows what that would mean at the end.
Well, I want to turn from one high-profile shooting to another. Remember when we were talking a lot about Ahmaud Arbery? Well, big development. All three men in that case have officially been charged. A grand jury laid down an indictment bringing 9 counts against each of the defendants here, Gregory and Travis McMichael, as well as William Bryant. They're facing malice murder, felony murder, aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment. Lydia, let me turn to you. Well, this is a big development here. Now we're dealing with a grand jury indictment. Was there anything about this that surprised you or shocked you in a way? I mean, these are really serious charges, and they're all facing the same thing.
The fact that they're all facing the exact same charges was a little bit surprising, because the participation from each one of these defendants was different. Of course, we know that it was the McMichaels initially. There you see them, Gregory and Travis McMichael, that were the relatives that pursued Ahmaud Arbery through the neighborhood as he was jogging on their truck, and fired shots. And as the narrative was initially unfolding, it was William Bryant who was recording this incident all along. And there he is. And it took a little while, but we later learned that he was not just this innocent bystander that he did to be, and that rather it was that he was an more active participant. Now, exactly what his role is and everything, I think we will continue to learn, but he was not the part of a trigger person. He was not, did not present himself to be initially with the McMichaels initially. So the fact that he is facing the same charges as them was a little bit surprising. And exactly how those charges will be proven and established against Brian, I think is something that I'm waiting to hear more about.
Yeah, then again, in the last hearing we heard that he actually blocked him in with his car and hit Arbery with the car. There was a dent in it, apparently. Terri, for people who are looking at this and say, wait a minute, I thought they were charged. What does this mean? Why is this important? What does this mean for the case moving forward? Why is it important to have this indictment? And what does it mean in terms of next steps, Terri?
Well, first of all, we have to remember this is the 4th prosecutor who's on the case. So he can look at the evidence and determine what he wants to bring as far as the case is concerned. And they decided here that in addition to the preliminary hearing where charges were brought, they would have a formal grand jury. And now we see that there are 9 counts against all 3 of them. And frankly, I do think that makes sense now that we do know that Bryant was involved in cornering Ahmaud Arbery and, in fact, actually hit him with the car. So I think we're going to see that this is going to move forward for a grand jury. There are 23 who sit, 16 just a simple majority. They all determined that all 3 of these defendants have to move forward with these charges.
Well, clearly it's a major development, and moving from one major development to the next, let's go on to another case we've been following, Breonna Taylor, the EMT who was killed in her own home after police raided her apartment thinking it was a source of drug operations, even though it was not. Well, after 3 months, one of the officers involved in that shooting has officially been fired. Brett Hankinson was relieved from the LMPD in a scathing letter by the chief. This was announced by the mayor. Take a listen.
Chief Schroeder is today initiating termination procedures against Louisville Metro Police Officer Brett Hankinson. Unfortunately, due to a provision in state law that I very much would like to see changed, both the chief and I are precluded from talking about what brought us to this moment or even the timing of this decision. I know that you will have questions, and I'm sorry that I cannot answer them because of the state law, ARS Chapter 67C.3261F.
Well, Julie, he talks about having questions. I have questions. If you read this letter from interim Louisville Police Chief Robert Schroeder, this thing is really scathing. He says, I find your conduct a shock to the conscience. Your actions have brought discredit upon yourself and the department. You have shown extreme indifference to the value of a human life. Almost reads like an indictment. Does that mean that we may see criminal charges brought against Mr. Hankinson soon after?
You know, I don't know that he has a say in any way as to what the prosecutor ends up doing. I think we've been waiting quite a while for them to make a decision as to whether or not there's going to be a prosecution in this case. I think, you know, look, I can't speak for what the prosecution is doing or not doing. I mean, with this specific I already called him a defendant, Mr. Hankinson, you know, 10 rounds were fired into the apartment. I think there's issues not just about the actions of the police officers, but one of the bigger issues that I always think about is these no-knock warrants that got us here in the first place.
Yeah, and they've come under scrutiny as well. Lydia, how does this affect the other officers? Because the other two officers involved, they haven't been fired. They've been put on administrative leave or administrative reassignment. No criminal charges filed against them. How will this development affect them, especially if you want to take the position, if you were an attorney representing them at this point, what would you say to expect?
I would say to expect that they need to be prepared for some internal investigations. Make sure you prepare to maybe have some inquiries about being placed on administrative leave while an investigation is still ongoing. I mean, look, it took 3 months to get to this point. Definitely seems like the department that they're working for is making some inquiries about what exactly happened when they were executing this no-knock warrant. So questions are still being asked, even though we are 3 months down the road, and many say that's 3 months too long. But clearly, they're still making some decisions about how to handle the officers that were involved. So for the other two, don't get comfortable. I would say you might be asked to answer for your own conduct in this incident.
Well, it's a very disturbing case, and clearly with more pressure put on, especially from the public who are demanding answers, we may see this case heat up soon. Now, look, we're going to take a break, but when we come back, we have a big show. We have a big lineup. We're going to talk about Robert Durst, big hearing there where his motion for a mistrial was denied. And then we're going to talk about the Bubba Wallace incident with NASCAR, as well as Bill Cosby. Stay tuned. We'll be right back right after this. All right, turning now to Robert Durst. You remember him on trial for the murder of his friend Susan Berman? He didn't have a great day yesterday because he lost his motion for a mistrial. Now, his trial, which was underway back in March, it was halted suddenly because of COVID-19. His defense team said, not fair to start the trial back up. You got jurors who were away for a while. They're not going to remember the case. Big danger starting a trial back up in the middle of a pandemic. They made all these arguments. Prosecution said, this is just a ploy to keep this going, to have a mistrial. It's just a way for them to start over. The judge agreed, denied the motion for mistrial. There's a hearing set on July 17th. And if there are really no issues, this is going to start up again July 27th. I'm going to get into that in a second. Let's start with some of the defense's arguments, and there's a lot here. This point was interesting, basically saying you have jurors who've been home for 3 months. You don't think that they looked at the TV or read anything about Robert Durst? Take a look.
I'm going to interrupt you, Mr. Chesnoff. The jurors have now received 3 admonitions after the final admonition. They're admonished again.
Most respectfully, Your Honor, we were not aware of that, and we appreciate your telling us, but it's still, as the cases state, and as I will talk about in a few moments, the courts recognize, as much as you would like to believe that they're going to follow the admonition, when they're at home for this period of time, the courts have all found that you don't have to show actual prejudice. The fact remains that there's a presumption that they have been exposed. The state makes much of the fact that several of our cases describe requests for a continuance rather than motions for mistrial. But that is a distinction without merit, Your Honor. The people fail to appreciate that those cases are predicated upon our highest court's unequivocal belief that a 2-month hiatus, less than half of our situation, would and does create an impermissible risk of exposure to outside influences, and to the real concern, regardless of good intentions of the juror or the court, that memory fades as to the evidence heard. Equally unconvincing and undeniable, in spite of the state's gratuitous comment that it is laughable, is the people's suggestion that the lack of justification in the Santa Maria case for an adjournment is comparable to the instant case. We agree that COVID-19 provides a far more compelling reason to mistry our case and to start all over. As Santa Maria held, the longer the separation, the greater risk of outside influences. That case held that an 11-day continuance, which was granted, far exceeded the limit of experience and reason, and most importantly, the due process right of the defendant. After all, our unprecedented delay involves as a matter of law the reality that prejudice will result, and Mr. Durst will be denied due process. The people can't distinguish the authorities we cited other than to say some dealt with continuances as opposed to mistrials. More significantly, they have wholly failed to cite a single case saying a delay of 135 days should not be a mistrial. Not one reported decision in the annals of recorded American jurisprudence. The defendant is not asking for a do-over, Your Honor, just a fair and fresh start.
Then Chesnoff makes the argument, and this is a pretty interesting one, that because of COVID-19, all the attorneys might not be able to come to court. It's not safe. Here's what he had to say about that.
Mr. Durst has chosen lawyers that have been with him for many, many years. He is therefore constitutionally entitled to them. This honorable court has commented on our abilities, and we have all appreciated your belief in our skills, and therefore reiterate that Bob Durst should not lose his counsel of choice because of a vile disease. The court also has Mr. Lewin as a prosecutor, whose skill and talent Mr. Durst deserves lawyers he believes are up to the challenge of such a worthy adversary as Mr. Lewin and his team. Your Honor, patience will lead to a safe resumption of this prosecution and of this defense. Where there is an erroneous deprivation of the right to counsel of choice, the result is reversal, with no additional showing of prejudice. In other words, why not grant a mistrial and avoid a trial that would be reversed if Mr. Durst's 3 lawyers aren't present? Certainly, Your Honor, that is not judicial economy. Mr. Sabelli's thoughtful and thorough declaration comes from an advocate whose sole mission as a lawyer is to see justice done for defendants worldwide. His declaration includes the detailed report from the NACDL, the most highly respected organization guaranteeing people accused of crime of their constitutional protections. It is clear from those 2 exemplary sources that a trial without Mr. Durst's counsel of choice would be an affront to everyone's constitutional rights guaranteed by the 6th Amendment, and the NACDL and Mr. Sabelli have taken an interest in this case because it is of national interest, because it is the Durst case. Assuming arguendo that the court did start again before it's medically safe, Mr. Durst, who is hard of hearing, will be 6 feet away, an arbitrary distance for alleged safety from counsel, and will not be able to effectively communicate with his lawyers. Mr. Durst suffered from esophageal cancer, cervical spine stenosis, hydrocephalitis, chronic urinary tract infections and blockage, chronic lower gastrointestinal dysfunction. He presently now has a growth in his bowel, and he suffers from chronic fatigue. Actually, the reason that Mr. Durst has not gotten COVID is because of his isolation. It would be ironic that moving him from the jail where they have him in complete isolation to a courthouse where he could contract it, it would be ironic that he spent all of his time avoiding a disease only to be impacted by it because of a rush back to trial.
Terry, I don't know. You know, we're living in unprecedented times. He's making some really serious arguments here, health concerns, safety concerns, constitutional right concerns, yet the judge did not buy it. Is that the right decision here?
It was absolutely the right decision here. And as the judge listened to defense counsel's argument, it looked as if he was saying, oh my goodness, when are you going to finish with all of these arguments? I do think the two arguments he made on this clip, the fact that there's risk of exposure as far as the jury's concerned, and the fact that they might lose the attorneys that are trying the case, was not the best argument to make. One of the real issues here, I think, and I don't know how they're going to cure this, how will the jury remember what was said? We've had an opening statement by both sides. We've had witnesses. How are they going to refresh the recollection of the jury? That, I think, is the real issue.
Well, Terry, it's a great question. And Lydia, I'm going to turn it over to you. It's our understanding, based upon what we heard, that both sides will have an allotment of time to maybe redo their openings, highlight some key points for the jury. Is that enough to bring a jury back up to speed after 3 months of isolation?
Well, I'm sure Mr. Durst's attorney would argue that it's not enough, that it would not be adequate to cure any memory deficiencies. But look, this is not an issue that's unique to Mr. Durst and his trial team. These are issues that are being confronted by courtrooms, judges, trial teams across the country from coast to coast. And so I think Terri is right in that the judge made the right decision in not granting a mistrial here, because if you think about it, if every case that was at some kind of, the trial had been started, or is that some type of they had momentum in it, if they restarted, not just paused and then resumed, but go back to the beginning of every case, that is a huge waste of precious judicial resources. It just doesn't seem
And look, we know there's a backlog
doable
of cases anyway, but Prosecutor John Lewin said this is an excuse. Don't believe the defense. Let's listen to what he said yesterday.
The defense in this case, Your Honor, has asked for mistrials every day of the trial, and most days they've asked for mistrials 3, 4, 5 times. They've asked for mistrials, as the court is aware, on a variety of issues, at least 5 that I can think of, none of which had anything to do with COVID. So I think, Your Honor, we have to be realistic, and we have to go back and say, okay, is the COVID situation a legitimate issue? Absolutely. It is completely legitimate. But for the defense to get up and say to the court, Your Honor, we want to pursue on with this case. We've always wanted to proceed with this case. No, they don't. They made mistrial motion after mistrial motion. So that's just not accurate. It's not correct. And the court can certainly, Your Honor, and this is important to us, Mr. Durst is a very wealthy man with a lot of lawyers. That's his right. It's his money. He can do what he wants with it. But he doesn't get his own sense of justice. He doesn't get his own process of justice, which is different from everyone else. He doesn't get a do-over because he's not happy with whatever issues he's not happy about, which the court's well aware of what those are. So I think when we're looking at the arguments the defense makes, we cannot dismiss the idea that in the end, this is gamesmanship on the part of Mr. Durst. And in the end, Your Honor, although he has attorneys, Mr. Durst is responsible. Ultimately, it's his case. These are his decisions. And Mr. Durst has made clear the decision he wants is, I want a do-over.
All right, Julie, I'm going to ask you a two-part question here. Just because of this ruling, one, do you think the defense is not going to try to delay this even further? There's a July 17th hearing, and if everything's okay, it's going to go to July 27th to start up again. And number two, really, does this benefit either side by starting this case up again? The prosecution wanted to start up. Does that mean that this will benefit them in any way?
Well, I'm going to go with the second question first by saying, many defense attorneys like to do that do-over. And why? Because they get a second chance there weren't that many witnesses that testified, but they get a second chance to cross-examine them and potentially be able to step on whatever they testified to before. Do I think in terms of the July 27th date, I think we forget, one of the things we have to keep in mind is that, COVID in terms of the cases are growing in California. So there might be issues going forward in terms of this stopping again. I may feel a little differently than Terri and Lydia. I think that the defense, while has cried, has cried wolf many times, I think this is the one time it's pretty legitimate. 3 months with the jury not hearing anything. Their presumption of exposure to this case, although no one's really talking about Durst the past 3 months. But that is a factor. Two, the fact that one of the biggest things to me is that you can't be right next to your client. We do these Zoom meetings all the time with our clients. I cannot conduct my hearings or anything because my client's not with me. And that's incredibly, incredibly difficult, especially for a murder case to go forward without him being right next to you.
Julie, I take exception to that. We have been talking about Robert Durst for the past 3 months. So I take exception. I just wish the jurors are not watching this. They shouldn't be watching Law&Crime Now. That's what they shouldn't be doing. But it looks like it'll start up again, and we will cover it here on Law&Crime for the latest updates. Now, when we come back, we have two big subjects that we're going to talk about. The latest with Bubba Wallace and NASCAR, and Bill Cosby is granted an appeal. We'll be back right after this. Welcome back, everybody. Now to NASCAR. After it was claimed that a noose was left in the garage of Bubba Wallace, who's the only African-American driver in NASCAR, the U.S. Attorney and the FBI released a joint statement saying after a thorough investigation, there is no evidence of a hate crime, that this noose was actually a garage door pull rope, and it was left there since last October. Now, this is interesting because they also said that it cannot be shown that no one would have known that Wallace would have been assigned that garage, which he was last week. Here's Wallace's reaction today on NBC News.
I was relieved, just like many others, to know that it wasn't targeted towards me. But it's still frustrating to know that, people are always going to test you and always just going to try to debunk you. And that's what I'm trying to wrap my head around now from saying I'm a fake and all this stuff, and that I reported it when it was news that was brought to me. It was information that was brought to me. The photo evidence that I've seen and that I have in my possession of what was in our garage is exactly a garage pull. It is. That is a noose. So it's, I don't know when we'll get to the point to release that.
Terri, I want to start with you. Is this the end of the story? Look, NASCAR, I know, is going to be conducting their own internal investigation here, but there's still confusion as to whether this was a noose or not. And if it was a noose, then isn't there have to be an investigation? Well, who left it there and why did they leave it there? If it's not a noose, is this simply just a case of a mistake? People believe one way, or is this a case of false reporting and someone needs to be held accountable? How is this going to play out moving forward?
You know what I find interesting? This is such a supercharged time in our history, and I think no one is going to be pleased. There are those who think that this was intentional and that the FBI came to a conclusion too quickly, and there are those who think that this was just a mistake. This noose was there before. It was a garage pull. I can tell you this. I'm from Birmingham, Alabama. Tallahassee or Talladega is only about an hour to the east on I-20. And in this Southern rural situation in Alabama, there is a lot of racism and there is reason to have fear. So I think they should have investigated it. And I think it was a legitimate investigation based on what I've seen so far. And if it was there before and no one knew that Bubba Wallace was going to be in that particular garage, then I think they've come to the right conclusion. But again, here, this is the kind of situation because of where we are right now in such a charged environment. You're not going to please anyone. Everyone is thinking that there's some other story here. And in fact, I think this might just be the end of the story.
And there are people who are quick to jump to conclusions. And Lydia, I want to say that because I saw in the news people compared him to Jussie Smollett, which is not fair, since in this case he said he was brought, this noose was brought to his attention. It's not like he just went out there and deliberately reported that. Having said that, he says he has to fight off people who are calling him a fake and that he has to fight for his credibility here. Should he be concerned, or really should he just stay his ground and say, this is what I believe? You can call it a mistake, but there was nothing I did that was wrong.
You know, I think it's really hard to say because I can only imagine that he's, in a difficult position right now. This whole incident with this noose in the garage is kind of coming on the heels of NASCAR making the decision to ban the use of the Confederate flag. That decision, sparked a lot of blowback from people in that area. I spent a couple of years reporting in Alabama and have been to Talladega, and I saw myself how many Confederate flags were waving around the racetrack by so many fans, and I was taken aback. And for many, obviously that is a symbol of racism. And for others, it's just a symbol of, they would tell you, being proud of being from the South. So, I think it's a very painful moment and a point of reflection and dialogue for so much of the part of the country. And for, Bubba Wallace to be caught up in the middle of this, with having learned from others that work for NASCAR that there was a noose found in his garage, and then being asked to, reflect being the only African American in the highest circuit of NASCAR at the center of the sport where the Confederate flag was now banned. That's asking a lot of anybody. So I can only imagine what he's going through.
Yeah, and it was much better the other day when you saw that show of solidarity for him with the pushing of the car. So we'll see which way this shakes up. It's just a really ugly story any which way you look at it. Speaking of things that are really, really ugly, let's move to Bill Cosby, because Bill Cosby, the man who was convicted of sexual assault and sentenced to 3 to 10 years in prison, a higher court, the highest court in Pennsylvania, has agreed to hear his appeal. Julie, this is big here because they're going to be basically ruling or hearing about all these evidentiary issues. Should this have been allowed? Should this not have been allowed? One of the big ones is whether or not these prior bad acts witnesses, these other accusers, should have been allowed to testify. Your thoughts on the court hearing this specific issue and which way they may lean?
So this can't help but bring up Harvey Weinstein, because I think anyone looking at this is going to start to think how it's going to impact that as well. And so what I think is so unique about this case is we've had a chance to see what would happen if there was only one prior witness that would testify about a bad act, because that's what happened originally in the Bill Cosby case, and they couldn't come back with a verdict against him. It wasn't until the judge arguably changed his decision, allowed in multiple prior act witnesses, that the jury was able to convict. And I think that's going to be a strong argument why the defense says they didn't make this decision based on the actual complainant. They made the decision based on the various witnesses that testified, and that's what's prejudicial. I also think the second issue regarding the statements that Bill Cosby made during the civil litigation is also going to be a pretty strong argument, at least as far as I'm concerned, regarding the defense, for the defense as well.
Let's talk about that. So, Terry, that argument is Bill Cosby made some sort of agreement with a former prosecutor saying, you can't charge me, I'll agree to be deposed. In his deposition, he said things that ended up hurting him. They're saying now with the defense that was really improper, totally unfair, and that is one of the main issues in his appeal. Your thoughts?
Listen, he was under oath. And so whatever he said in a civil trial while he's under oath in a deposition, is going to be used against him. I think that his attorneys should have advised him and to be careful what he had to say. And I think it's fair play. I think you can use anything that was said out of court under oath in the case against him. So it's, too bad, so sad, as my law school professor used to say.
Well, I'll tell you this, I don't think there's a lot of sympathy through Bill Cosby. Lydia, I'll give you about 20 seconds. Just because they've granted his appeal, to hear these arguments, does it mean he has a chance of getting a new trial or his conviction overturned? 20 seconds.
It's all going to be based on what the standard of review here is. And my understanding is that the standard of review is going to be awfully deferential to this trial court judge who made decisions using the judge's discretion for admitting this type of evidence. So it will be tough. It's not a slam dunk.
Well, it's pretty remarkable. You have an 82-year-old who's being granted an appeal. So there's a lot at stake for him. His family of supporters are clearly in his favor, but the evidence against him was pretty strong. So we'll wait and see what happens there. I want to thank everybody for joining me today. We will be back later on in the week. See you then.